We'll move to the second part of our panel by discussing the experience of lawyering of Jews in two other countries. Our third speaker is Professor Kenneth Ledford from the Department of History at Case Western Reserve University in Cleveland. Professor Ledford earned his PhD from Johns Hopkins University. He is an expert in the fields of German legal system and German legal history, as well as in European history. He has published numerous articles and books. Amongst his publications, the book From General State to Special Interest, German Lawyers, 1878-1933. Professor Ledford will talk on the Jews in the legal profession in Germany from a historical perspective. He will focus on three stages in this context, from the Emancipation in the mid-19th century to Assimilation in the first decades of the 20th century until the Exclusion in the Third Reich. Professor Ledford, please.
I too would like to thank the organizers for including me. It's been a stimulating conference for me, and I hope that my entry in the competition for who's the most outside doesn't seem too remote, although I suspect that Mitra will best me very shortly and supplant my claim to be the most remote from the main topic of the conference. This paper is not something that I've focused my primary research on, but it's something that, after having spent a good part of 2 decades working on various legal professions, I've done the book on private practitioners, and I'm writing a book about the Prussian judiciary now. It was clear to me that I had a lot of information about this, and it was just a question of synthesizing it. So that's what I've tried to do here in a survey for people whom I take to be non-German specialists. If anyone here is a specialist in Germany, I apologize to you. In June 1905, District Court Judge Franz Paul Rosenthal in the Neubrandenburg Prussian provincial town of Landsberg an der Wartha was frustrated that his career advancement had ground to a halt in such a minor place. So at the age of 57, he applied to retire. His application was endorsed by his supervising judge, forwarded to the Ministry of Justice. He was awarded the typical medal one got upon retirement, given his pension, retired, and moved to Berlin. But he apparently wasn't ready for repose. 2 years later, he wrote the Prussian Minister of Justice to seek reappointment as a judge at some district or superior court near Berlin, so he could be near his adult children. And the Justice Minister turned to the presiding court of the presiding judge of the regional court, the Kammergericht in Berlin, for his opinion of this petition, and the judge responded in a most revealing fashion. In the opening recitation of Rosenthal's vital statistics, the presiding judge included not only his date of birth, his religious confession, Mosaisch, polite terminology for Jewish, a datum that had been entirely missing in the transaction 2 years before. The Kammergericht president expressed skepticism that after only 2 years of retirement, his health could have recovered. But then he added, regardless of his health, I cannot support his reinstatement in view of his frequent unsatisfactory conduct during his career, as indicated on pages 116, 131, 161, 183, 193, 232, 233, 258 of Volume 1 of his personnel records, and pages 4 and 16 of Volume 2, as well as pages 85 and 109 of his disciplinary case record. This was a happy day in the archive. Acting upon this recommendation, the Justice Minister declined to restore Rosenthal to the bench. Rosenthal, it turns out, was that relative rarity in the German Empire, a Jew appointed to the Prussian judiciary. Clearly a talented, intelligent, and able man, he had pursued his study to the point of obtaining a Juris Doctor degree, not something that very few did. Rosenthal's career was marred not only by personal failings of arrogance and laziness, but by the frustrating dilemmas of 19th century German Jews who sought careers in the legal professions. Many talented Jewish lawyers triumphed over these frustrations, but Rosenthal succumbed. And in many ways, his story of failure illustrates these other stories of triumph. In this talk, I'm going to return to Rosenthal at least once as sort of an example of the dilemmas of Jewish experience in the German legal professions from the 19th into the 20th century. But embedded in the larger history of Jewish presence in German culture and society, intertwined with the history of the rise and fall of liberal, political, economic, social, and especially legal ideology in Germany, Jewish lawyers and judges provide a study in microcosm of the emancipation, assimilation, and exclusion or extermination that all German Jews experienced in Germany's transition to modernity and to postmodernity. And I will argue that Jews in the German legal profession were in many ways the miners' canaries of German liberalism, and that their fate cannot be understood apart from an inquiry into the fate of liberalism and its supporting legal ideology in the 19th and 20th centuries. Now, first to emancipation. The politically fragmented nature of 18th century Germany had led to a similar fragmentation in the legal regulation of Jewish life. The absolutist regimes of the German kingdoms, duchies, and principalities within the Holy Roman Empire of the German nation, come on, say it with Voltaire, which was neither holy nor Roman nor an empire, right? Hardly provided any guarantees of rights for any Christian subjects before the promulgation of the Prussian General Law Code of 1794. Not to mention any guarantees for Jews who were barely tolerated residents. Everywhere, Jews lived in Germany subject to significant civil disabilities as tolerated subjects of the state who indeed enjoy its protection but are in no way members of civil society. In such circumstances, the question of Jews studying law and entering into legal professions was simply not raised. But in the course of the 17th and 18th centuries, a small segment of the Jewish population, often under the direct protection of one or another of the German royal or ducal courts as Hofjuden, emerged as financiers and entrepreneurs and entered life outside the Jewish community. By the mid-1700s, a group of Jewish intellectuals coalesced in Berlin around the monumental figure of Moses Mendelssohn, perhaps the leading figure of the entire German Enlightenment, and in conversation with non-Jewish Germans, such as Friedrich Lessing, began to contemplate the civil emancipation of Jews. All envisioned a period of civil improvement, bürgerliche Verbesserung, for most Jews, meaning the opportunity for poor, insular Jews to attain the benefits of cosmopolitan and German culture before being fully admitted to the rights of citizens. Alongside this emancipatory civil improvement, and as an essential part of it, Jews began, very gradually at first, to pursue both the neo-humanistic classical secondary education at the gymnasium that was a precondition to admission to university study, and to study in small numbers at German universities. Now, there's a big literature about this, most of it in German, and I'm going to go through the numbers pretty quickly. The first 4 German Jewish law students entered the University of Königsberg in 1788, and the small numbers followed. The problem was that under the prevailing system, all law-related careers remained closed to Jews, no doubt deterring many who would otherwise have pursued the study of law. Conversion to Christianity immediately opened the door to entry into legal careers, although social discrimination often extended to converts. For example, in 1799, Isaac Elias Itzig, a member of a prominent Berlin banking family who had studied law at university and had himself been baptized, sought admission to the period of practical legal training required before becoming a judge or advocate. The Minister of Justice objected, arguing that Itzig's family connections to his still Jewish family should disqualify him. But the King of Prussia decided, quote, that a Jew who has converted to the Christian religion, even if he remains still connected to his Jewish family, nevertheless can be admitted to the justice service